One of you had alluded to the memo from the White House counsel to the Secretary of Homeland Security that directed him to interpret the order in a certain way.
Yeah.
What do you make of that? And does he have the legal authority to do that?
For the White House counsel to interpret the order and direct DHS to interpret it that way?
Right.
No. The White House counsel's office has no power, has no interpretive power or power to tell anyone what to do at all. They're not an agency. I mean, they have the power to give advice to the president about the law. We do have branches that can make authoritative rulings. We have the OLC, the Office of Legal Counsel, within the Justice Department that does that kind of thing. That's what they're there for. I mean, they have, they're independent of the White House and the political process. But no, the White House, I mean, this is one of the reasons why the Ninth Circuit said we can't use the White House counsel's interpretation as a limitation on the order because they just don't have that power.
Yes, in the back corner.
Yeah, going back to the reviewability aspect of the executive order, you talked about the president cites to the 1880s for his legal position. What does the opposing side, do they have any legal footing to cite to, or it's just they don't like the idea that the order can't be reviewed?
Well, they cite to a bunch of cases that are outside of the immigration context, like Boumediene, which is one of the Guantanamo challenges. Congress, and Hamdi, Hamdan, and Rasul, all of which were challenges to the Guantanamo case, Guantanamo designation. And there's some others. I have the executive order right here. I can check to see what the court cites do. But essentially, they cite to a bunch of non-immigration cases to say claims of unreviewable power to unreviewable executive power are strongly disfavored, and especially in a context where there are viable constitutional claims. The idea that the president can turn off the Constitution at will by simply designating a group, the court says that can't be right. I mean, the 1880s case. There's no case since then that establishes a class of, as far as I know, and Peter may well know better than I do because I'm not an immigration lawyer, but a case where you have a class as broad as the one that was at issue in the Chinese Exclusion Act, I think would be hard to find. And there certainly isn't a case like at least what the challengers say this one is, that is a ban based on religion that applies to 7 different countries targeting religion. And we don't have a case as broad as that. There may be some cases where they say, well, they excluded a class, but no class as broad as the Chinese Exclusion Act case, or this case, at least as the challengers see it.
There are 2 things to say about that. So one, in terms of the provision, the statute that Deb alluded to, which is 1182F, that says the president can restrict entry of any alien, that's the word in the statute, so we use it, or any class of aliens. The history has been, the practice has been, that usually that's been a pretty targeted kind of measure. So for example, President Reagan said, I'm going to exclude Cubans because the Cuban government reneged on their immigration agreement with me, where they said we're going to stop people from illegally emigrating from Cuba, taking rafts from Cuba to the Florida coast. So Reagan said, I'm mad at that, so I'm going to retaliate against Cubans. That's a perfectly rational exploration of foreign policy power, but it's targeted. It's designed to get Cuba to clean up its act. Okay? Or Reagan also said, I'm going to refuse entry to associates of former Panamanian dictator Manuel Noriega. Again, a very targeted kind of measure. And so I think past practice there is something that the Supreme Court could look to and say, historically this hasn't been used. Even though its language seems to be broad, it hasn't been used for the kind of breadth that it's being used for in this executive order. Instead, it's been more targeted and tailored, and just as in the classic separation of powers jurisprudence, in the Youngstown case, where Justice Jackson's concurrence really holds sway, you'd say past practice makes a difference, and you should view Congress as ratifying that past practice, perhaps not ratifying something more expansive like what President Trump is doing now. But the flip side of that, because with immigration things are complicated, is that if you look at matters from the other perspective than the one Jared mentioned, instead of looking at what Congress, what the court rather has upheld, look at what is struck down. What is struck down in the immigration field? The answer is there's one statute, one, in the past 150 years that's been struck down. That was the portion of the immigration statute that provided Congress with what used to be called the legislative veto, to summarily veto any action in immigration taken by the president. And the court said in that case, the Chadha case, that that was unconstitutional. Not because of substantive problems with the act, but because it violated the separation of powers. Because if Congress wanted to act, it needs to do things the old-fashioned way, get a bill signed, and then get it signed into law by the President of the United States. Because the legislative veto doesn't go that route, the court said we'll strike it down. But as the substantive classification between countries or any other basis, there's no Supreme Court case that strikes down a statute. And that's why I'd say it's not at all clear that these cases from the 1880s in immigration are now bad law. Many other cases from that era thankfully are, like Plessy versus Ferguson, that said separate but equal is okay. We know we went beyond that with Brown v. Board of Ed in 1954. You can't say that about immigration, and as I said to our group in Bristol a week or so ago, I ask my class every year, suppose we had a statute that said, in order to decide who gets to enter the United States and who doesn't, we have an immigration officer toss a coin. It's not clear that would be unconstitutional. That's how deferential the case law is in this particular area. So when it comes to immigration, as Dorothy said to Toto, you're not in Kansas anymore.
Right, but I take it, but you and I have had this discussion too. Do you think that there's some limit where a court would step in if the policy really was blatantly no Muslims allowed, no Jews allowed?
Yes, I
think the court would say that you know here.
I think a clear religious test would be problematic. I also think, again, there's statutory arguments for saying that what was done here, at least with respect to both LPRs and visa holders, is arbitrary under the statute. And maybe that would go into a constitutional type of argument, the kind of argument was made, for example, by the court in a case called Kent versus Dulles, that involved depriving a U.S. citizen of the right to travel, stripping of his passport. And the court said, we won't read the statutes conferring that broad a delegation on the president. The delegation has to be more narrowly tailored. So I can see that.